All right, good morning. Welcome to the 294th District Court. I am Judge Chris Martin. I'm going to call this morning's docket. When I call your name, please say here or present. Sean Palmer. George Jumper. Everett Summit. Everett Lee Summit. I believe Mr. Wells may be in the hallway. Mr. Summit. Christian Sherwood. Christian Sherwood. Okay, thank you, Ms. Sergeant. Chad Derek Williams. Thank you, Mr. White. And I know we have Calvin Dunn, who's incarcerated, and we also have Tanya Red, who's incarcerated, and they're going to be appearing via Zoom, is my understanding today. Good morning, Mr. Adams. How are you?
Oh, well, Judge, how are you?
I'm doing fine. Mr. Dunn's going to appear via Zoom. They may not have that set up at the jail yet. I don't see that, but as soon as he gets here, I'll take Mr. Dunn up and get you going. Okay.
No trouble.
Mr. Green, what are we doing on Mr. Palmer today? You're muted.
Yes. Mr. Cox and I had an agreement subject to your approval to move that to September 15th date for him to consider an offer to resolve the case that he needed to do some research on.
Is that right, Mr. Cox?
That's correct.
All right, then based on the parties' agreement, the court will reset Mr. Palmer for a hearing on his motion to adjudicate to September 15th. Mr. Palmer, if you'll come up to the podium, please, sir. Mr. Palmer, I don't know if you heard, Mr. Green's appearing via Zoom. You should be able to see him here. He's requested the court to reset your hearing today until September 15th, which the state has agreed and the court has also agreed. So I'm going to have the bailiff here provide you with a copy of our notice of appearance. Once you sign that, then you'll be free to go. And once you're done, then I need you to go down the hall to the left and see Miss Patty Tabraham. She wanted to speak with you this morning, I believe.
What time is it, Judge?
9 a.m. No, just have him. Just have him sign up there. Good. Ms. Heisel, while they're doing that, is Mr. Sherwood going to be a plea this morning? And Mr. Wells, you're ready on your PTI?
We are good.
All right, court calls CR 2202, State versus Everett Lee Summit. Mr. Summit, if you'll come to the podium, please. Is this the same one?
I believe so, Judge. This copy has Mr. Summit's signature
Oh.
on the requirement claim. I believe that's the only difference.
Okay. All right, Mr. Summit, if you will, raise your right hand. I'm going to place you under oath. Mr. Summit, do you swear that the testimony you give today to the court will be the truth, the whole truth, and nothing but the truth, self you God?
Yes, I'll hear.
Okay. All right, you are Everett Lee Summit, is that correct? Mr. Summit, you've been charged by indictment with the third-degree felony offense of possession of a controlled substance in penalty group 2, greater than or equal to 1 gram but less than 4 grams, a third-degree felony which carries a range of punishment of not less than 2 years nor more than 10 years confinement in the Texas Department of Criminal Justice. In this case, you're represented by your attorney, Mr. Wells. Are you pleased with his representation of you? You feel like you've had sufficient time to discuss your case with him, have all of your legal questions answered? And Mr. Wells, do you believe your client to be competent today?
I do, Judge, just one thing is information after that.
I'm sorry, thank you, Mr. Wells. Do you believe he's competent today?
I'm sorry.
You believe he's competent today?
I do, Judge.
Okay. And it appears that, Mr. Summit, you want to enter into a pretrial intervention contract with the state wherein you would be pleading guilty to that offense for participation, for a recommendation of participation in that program for a period of 18 months. And you've gone over this pretrial intervention contract with your attorney, is that correct? Do you understand that there are certain terms and conditions to which you must comply in order to successfully complete the program? You also understand that by participating in the program, you're going to be giving up certain important legal rights. You understand that? You understand that you would be giving up the right to have your case tried before a jury of your peers. And I see here that there is a form entitled Waiver of Jury Trial. And this form appears to be signed by you, which would advise the court that you've discussed this with your attorney and you're asking the court to allow you to waive your right to a jury trial, and that you're doing so intelligently, knowingly, voluntarily, and you know that you're giving up your right to confront the state's witnesses and any evidence they bring before you. Is that what you're telling me today? And you're wanting the court to approve that waiver of jury trial? In addition to giving up your jury trial, you're also waiving your right to have your case indicted by the Van Zandt County grand jury. Instead, it appears that you are allowing the state of Texas to proceed in this case by the filing of an information. Do you understand that you have the absolute right to have your case presented to a grand jury and for that grand jury to determine whether or not there's sufficient probable cause to move forward in your case? You understand that by waiving that right, you're allowing the state to prosecute you by information only. And has anyone threatened you, forced you, or pressured you to waive your right of indictment? Okay, well, there was some hesitancy there. So has Mr. Wells, okay, well, I want to make sure we're clear. Has Mr. Wells or the state of Texas or anyone else pressured you, forced you, told you, you have to waive your right to indictment in this case? So you're doing so of your own free will because you want to waive your right to indictment so that you can accept the plea agreement. Is that right? Okay. And finally, you understand that you would be giving up your right to a speedy trial, and you would also be giving up some of your rights with regards to the expunction of your criminal records should you later have this case dismissed. Specifically, you would be waiving the right to have your records expunged with regards to the Van Zandt County DA's office and the Van Zandt County Community Supervision and Corrections Department, which means, Mr. Summit, if you successfully complete this program and the case is later dismissed as agreed in the contract, then the DA's office and the probation department will still maintain records on you regarding this arrest, this prosecution, and this disposition. And you're asking the court to allow you to waive those rights and waive your right to a speedy trial. All right, the court, based on the testimony of Mr. Summit, hereby finds that he has intelligently, knowingly, and voluntarily waived his right to a jury trial. He has also waived his right to indictment in this case, and he's waiving his right to expunction of certain records by certain agencies, and also waiving his right to a speedy trial in this cause. The court hereby approves the placement of Mr. Everett Lee Summit into the pretrial intervention program for a period of 18 months for the felony offense of possession of a controlled substance in penalty group 2 greater than or equal to 1 gram but less than 4 grams. All right, Mr. Summit, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the pretrial intervention contract. I'm going to have you go with Officer Maturi here.
Judge, if I could just add one thing to the record before we move on. Mr. Summit was, when he was arrested for this offense, also arrested for possession of marijuana. It is unfiled. It is DA clause number 2020-0103. We have rejected that case for prosecution agreement.
Okay, thank you, Ms. Heisel. All right,
Judge, if I might, one question.
go ahead.
Haven't you understand the lab is still pending, but you have assured me that you don't need the lab result for what this material was. Thank you. Is that right? That's all.
All right, thank you, Mr. All right. All right, Mr. Summit, you may join Officer Maturi here. Mr. Schmidt, what are we doing on Mr. Jumper today? I show it's set for docket call, but I'm not sure if that's correct.
No, it's a procedure order. We have agreement for a modification, the dismissal of the motion, and we find everything ready to go.
Okay, so paperwork's already been done. So state's withdrawing its motion to adjudicate.
Yes, sir, we're withdrawing it, and we're also going to dismiss it with prejudice, as part of our agreement.
And because I don't have the motion in front of me,
There's one count in the motion, Your Honor, it's a new offense at Henderson County. I spoke with the victim a couple of weeks ago. He does not wish to see this case prosecuted. I got an offense report from the Henderson County DA's office, but I copy that as well.
all right, so the agreement is to withdraw and amend and continue
Yes, sir.
with Mr. Jumper doing 30 days in jail.
Yes, sir.
He'll begin that today.
Yes, sir.
Is he in custody at this time?
We anticipated we going to custody forward. We didn't know if we wanted to go to the jail instead or how to proceed.
Yeah, we'll go ahead and take him now. Unless there's agreement otherwise.
No, that was our understanding of what was happening.
All right, Mr. Jumper, if you'll come to the podium, please. All right, Mr. Jumper, if you will, raise your right hand. I'm going to place you under oath. Mr. Jumper, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God? All right, you are George Tracy Jumper, right? Mr. Jumper, it's my understanding that the state has filed a motion to withdraw its motion to adjudicate in your case and is recommending to the court that with that being dismissed, they've reached an agreement with you wherein you will be submitting yourself as a condition of your community supervision to the Van Zandt County Jail for 30 days, for a 30-day term of imprisonment to begin today, ending on September 25th, 2020. Is that the agreement that you've reached with the state? Has anyone threatened you, forced you, pressured you into that agreement? And you're represented in this case by Mr. Brian Schmidt. Are you pleased with his representation of you? You feel like you've had sufficient time to discuss this case with him and have all of your legal questions answered? All right, the court's going to approve the amendment to the conditions of community supervision, amending Mr. George Tracy Jumper's conditions to include 30 days confinement beginning this date and ending September 25th at 6 a.m. as a term and condition of his community supervision. All right, Mr. Jumper, you're going to be taken into custody at this time. Have you step over here with my bailiff. Court's going to grant the order dismissing the state's motion.
Judge, if we're on the record of the hearing, just like reiterating for the record, that motion was the prejudice. We're going to say to my client, there was a future motion to proceed, that count could not be included because there was a consideration given in the modification.
your submission of our agreement. We're agreeing not to use that county jumper in the future.
Do you all want this motion, this order on this motion to withdraw to reflect that?
I think it does.
Here, once you approach and you look at that, if not, we can write that in.
What says with prejudice?
Where?
It says withdraw, though, not dismiss.
If that's fine with you.
Oh,
I'm just trying to save you from having to get a record if later it comes up.
Oh, I think with prejudice and with the agreement on the record, I've looked at some case law on this, it's sufficient for due consideration for dismissal of prejudice. I've no concerns.
Okay. All right, well, the court has signed that. I'll get it to the clerk.
Very good, man. Thank you.
Is that all you have?
Yes, sir.
Where's your mask at? That's it. Can't see. So, okay. I didn't want to assume what the other part said, because it's kind of wrinkled, so. Like you might be trying to slip one by me.
Thank you.
You're welcome. All right. I believe we have the jail court logging in now. We can take up Mr. Dunn. All right, good morning to the jail court. May have to unmute that device there so that I can hear.
Sorry.
That's okay.
You hear us?
Yes, I can. Mr. Dunn, will you come up and have a seat in that chair, please, sir? Good morning, Mr. Dunn. How are you, sir? Can you see and hear me okay?
Yes, sir.
All right. Can you see and hear your attorney, Mr. Adams?
Yes, sir.
All right. This is cause number CR 18308 and CR 18472, State versus Calvin Leroy Dunn. And today we're set on status of the in-camera review of the CPS records. Wanted to announce to the parties that I've not completed my review of those records, and I'm going to reset this for September 15th. Mr. Adams, I believe that I have you coming back on the 15th. Is that correct? Are you due to be in
Yes,
here?
Your Honor. That's right, Your Honor. I have a couple of cases on that docket that morning.
I lost a week in review of these records. I was unaware that they were provided to my office. And so once I sent out a message, I think you were all aware that I was inquiring about those, and then it was disclosed to me where they were. So lost a little bit of time on that, but I should have this done in advance of the 15th. So I'm going to set us for the same status of in-camera review on September 15th. So we'll have you back in court on that day, Mr. Dunn, and I'll have an announcement for your attorney and for the state on whether or not those CPS records will be released. Okay?
Yes, sir.
Very good.
Do you have any other issues, Mr. Adams?
None right now, Your Honor. No, sir.
Okay. All right. Thank you, Mr. Dunn. You can have a seat back at the table.
Thank you, Your Honor. That's all I have this morning on the docket. May I be excused?
Yes. Thank you, Mr. Adams. I appreciate it, sir.
Okay, certainly. Good to see you.
Good to see you. Still working on the plea for Mr. Sherwood, right? Mr. White's still working on that? Okay. All right, Mr. Green, are you ready on Ms. Red?
I am, Your Honor.
All right, court calls CR 15503, State of Texas versus Tanya Red. And I believe that we're set today on Mr. Green's request for bail reduction.
That's correct, Judge.
And do you want to Do you want to call Ms. Red or any other?
Judge, I do want to call Ms. Red for the limited purposes of the bail reduction hearing.
Ms. Red, if you will, raise your right hand. I'm going to place you under oath. Ms. Red, do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir.
All right, put your hand down. Go ahead, Mr. Green.
And Judge, just for the record, it's my understanding that the court set Ms. Red's bond at $100,000 upon granting the release of surety for her bail person. Is that correct?
Yes, sir, that is correct.
Okay. Ms. Red, would you state your full name, please?
Leah Louise Red.
And Ms. Red, it's obvious, but you're currently in the Van Zandt County Jail. Is that correct?
Yes, sir.
And you've been in jail since Tuesday, or been in custody since Tuesday morning, correct?
Yes, sir.
And you're currently on a deferred adjudication probation in your case, is that right?
Yes, sir.
And the state has filed a motion to adjudicate, correct?
Yes, sir.
And you had when that motion to adjudicate was first filed, there was a $100,000 bond that was set, is that correct?
Yes, sir.
And you were able to, on your arrest on that motion to adjudicate, you were able to make that bond, correct?
Yes, sir.
And that was made through Cindy bail bonds.
Yes, sir.
And I think you indicated to me that your fee to her was a $10,000 fee. Is that right?
Yes, sir.
And as of Tuesday, you had paid Cindy about $8,000.
Yes, sir. Exactly $8,000.
Is it fair to say that based on what you have already paid in a bond, that you don't have the ability to make a $100,000 bond?
No, I do not, sir.
While you were continuing, or while this motion to adjudicate is pending, you have continued to report to the Van Zandt County Probation Office. Is that right?
Yes, sir, I have.
And have you been participating in any of the outpatient counseling services?
I did. I'm starting with the new counselor. We did a few sessions already.
And recently you were became employed full-time, is that right?
Yes, sir, I did.
And that was at the Target Distribution Center over in Lindale?
Yes, sir.
And I think you told me that you started that job on August the 18th.
Yes, I did.
And that's a full-time job.
It is.
And that you work Tuesday through Friday,
Yes, sir.
and that's 10-hour shifts,
Yes, it is.
4 p.m. to 2 a.m.
Absolutely.
And as obviously you were arrested Tuesday morning, and I suppose that you were supposed to be at work Tuesday afternoon, is that right?
Yes, sir.
Any idea of the status of that job at this point?
My husband called them for me. I'm pretty sure if I can make it soon that I can salvage my job.
Okay. As far as where you're living, where are you living right now?
I live at 6335 FM 314 in Ben Wheeler.
And that's in Van Zandt County?
It is, yes, sir.
And how long have you been living there?
About over 4 years.
And is that the address that you provided to Cindy bail bonds?
It is, yes, sir.
And have you moved or been anywhere else other than that location?
Absolutely not, sir.
You have recently, I guess, maybe as earlier this month, had some heart issues.
Yes, sir.
and actually went to and was admitted to hospital in Tyler. Is that right?
Yes, sir.
And as a result of that, you've been placed on medication for blood pressure issues.
Yes, sir.
And I think they, do you remember the medication that was prescribed for that?
I do. It's metoprolol. I think that's how you say it. Something like that.
Okay.
Metoprolol. 25 milligrams.
And are you also prescribed nitroglycerin?
I am, sir, for chest pain.
All right. And is that a as needed medication?
It is, yes, sir.
All right. Have you, since you've been arrested and been in custody since Tuesday, have you been able to take your medications?
I have not.
So so that was the last essentially 2 days, 48 hours, 72 hours, whatever it's been, you haven't been able to take your medication.
No, sir, I haven't.
And do you know why?
I don't have the metoprolol with me, and I just haven't had access to my nitro, I guess.
Okay. Has the jail given you any indication of whether or not that they'll allow you to take that, or?
They have not, sir.
It's okay. Ms. Red, you understand if you make bond that you've got to continue to comply with your conditions of probation until this matter is resolved.
Of course, yes, sir.
And you're telling the court that you're going to do that.
Absolutely, yes, I will.
And that there's no risk of you fleeing Van Zandt County or going anywhere to avoid facing whatever the consequences may be related to this motion to adjudicate.
No, sir, we've been in Van Zandt County since 2003. I don't think we're going anywhere.
And as far as appearing in court, I think this case was originally indicted back in 2015. Is that right?
Yes, sir.
And you appeared on that case before it was resolved several times, correct?
Yes, sir.
And then this motion to adjudicate's been pending since sometime in early 2020.
Yes.
And you've been to court every time that you were required to be in court for the motion to adjudicate.
Yes, sir. Except for when I was hospitalized.
With the exception of that, the time that you didn't appear, or the time that you went to the hospital earlier this month.
Yes, sir.
And you provided, at the court's request, you provided verification that you had actually gone to the hospital and had been admitted.
Yes, sir.
I pass the witness, Your Honor.
State.
Can you hear me?
Yes, sir.
Okay. Ms. Red, the first time you came to court after we filed our motion to adjudicate, you knew you had a warrant. Is that correct?
I'm sorry, I couldn't hear you.
Judge, I'm having a hard time hearing Mr. Cox as well.
I'll change to this microphone here. I don't know if it's going to be better, but go ahead. If you'll speak into that one louder, but this one should be okay.
I'll try this one for now. Ms.
That is
Red,
better, Judge.
this is
At least for
better.
me.
Yes, sir.
Okay. Ms. Red, the first time you came to court after the state filed our motion to adjudicate, you knew you had a warrant active. Is that right?
I knew I had a warrant. Is that what you said? I did not. If you said warrant, I did not know I had a warrant, sir.
You had a warrant. But why did you bring your son to court that day?
Because I was supposed to come to court. I always go to my court appearances.
You always bring your son to court with you, or just when you have active warrants?
I'm sorry?
Do you always bring your son to court with you, or just when you have active warrants?
Bring my son. The day that I went with my son, sir, was to my husband's hearing, not mine, sir.
Okay, so it was
I
just,
didn't know I was going to be arrested.
okay, so it was just a coincidence you brought your son to court and you had open warrants.
Yes, sir, it really was.
Not because you thought you wouldn't get arrested if you had your son with you.
Absolutely not, sir.
The next time you came to court after that, you had to take a UA, isn't that right?
Yes, sir.
You tested positive for methamphetamine, isn't that right?
That's what they said, sir.
Okay, you denied use, correct?
Yes, sir.
It had to go off to the lab in Tyler for confirmation, right?
Yes, sir.
And your understanding that that came back positive for methamphetamine.
That's my understanding, yes.
How do you explain both the in-court test and the lab result coming back positive for methamphetamine?
I'm not sure.
Not sure?
I do not take methamphetamine, so I'm honestly not sure.
And then the time you came to court after that, you had to go to the hospital in Athens, right?
Yes, sir.
And then Tuesday, when we were going to take up that positive UA result, you had to go to the hospital again, right? Actually, no, I'm sorry, Ms. Ray. After you were taken into custody by the court and booked into the jail, you had to go to the hospital, right?
Yes, sir. Yes, sir.
How many times have you had to go to the hospital when you're not looking at going to jail?
I've gone several times before now.
Okay. So it's not just a coincidence then that anytime you're looking at jail, you either bring your son or you have a heart issue.
No, sir.
Who do you live with, Ms. Red?
I live with my husband,
What's his name?
Sean Palmer.
Okay. And he also has pending drug charges in this county, right?
Yes, sir. It's the same circumstance.
Okay, so you're going to go live with your husband who also has a drug problem.
We do not have drug problems, sir.
Okay. But you're on probation for methamphetamine, right?
I understand. Yes, sir.
Okay. I'll pass the witness, Judge.
Mr. Green, any additional questions?
Ms. Red, you came to court on Tuesday,
Yes, sir.
correct? And as far as any issues going to the hospital, the only time that you had court that you went was the one earlier this month, where
Yes.
you were actually admitted by the hospital for tests and diagnosis.
Yes, sir.
And is it fair to say that you've had several urinalysis while you've been on this probation?
Yes, sir.
And there have been urinalysis that you've passed?
Many. Yes, sir.
Are you trying to do anything to avoid coming to court or avoid whatever may happen in this motion to adjudicate?
Absolutely not, sir.
And we talked about what can happen, right?
Yes, sir.
And you understand that at some point, the judge could revoke your probation and you could go to prison.
Yes, sir.
You understand that's a possibility, although that's not what you hope happens.
Of course. Yes, sir.
And yet you're still coming to court.
Yes, sir.
I pass the witness, Sean.
Anything further from the state?
Briefly, Judge. Ms. Red, when the paramedics came to the hospital on Tuesday, they told you your vitals were normal, didn't they?
No, sir. They told me that my blood pressure was elevated.
Okay. So if the jail says your vitals are normal, they were incorrect?
Sir, the jail nurse is the one that suggested that I go to the emergency room, sir, not myself.
I'll pass the witness.
Mr. Green,
Nothing further, Your Honor.
any further evidence, Mr. Green?
No, Your Honor, we rest.
Any evidence from the state?
No, Your Honor.
You want argument, Mr. Green?
Judge, we believe in this case, and while Miss Red did make an initial $100,000 bond, and obviously the court understands, I think, the position that the court's in and defendants are in when a bondsman files a release of surety. Miss Red, we believe, was complying, not a flight risk, and it is what it is. But that by complying with her bondsman and that bond, bond has essentially tapped her financial resources out, although she does, if she does get out, has the ability to gain full-time or resume full-time employment and support herself and pay what she needs to pay. We believe in this case that a $20,000 bond is sufficient to assure that she appears in court as required, which she had been doing even under the O bond, with the exception of when she was admitted to the hospital for heart issues. I think that Ms. Red would be agreeable to, during the pendency of this motion, to adjudicate to report as often as the court deems that she needs to report, as including once a week, and given a urinalysis every time she reports to ensure that she is checking in and that she is not using any controlled substances. And Judge, that's what we would request the court to grant.
Thank you, Mr. Green. Mr. Cox.
Briefly, Judge, Your Honor, if Ms. Red were to get out of jail, next time, if it's not heart problems, it's going to be car trouble. Every time Ms. Red is confronted with the prospect of being taken into custody, she has some sort of issue that comes up that prevents her from going into custody. And the state is concerned that if she gets out, we may not see her again. We believe she's a flight risk. We're going to ask the court to deny this motion.
Thank you, Mr. Cox. Mr. Green, does your client stipulate that she was positive for methamphetamines 2 court settings ago? I mean, I've heard that asked. I believe that a concession has been made regarding that. I don't have that test in front of me. It's not been offered, but I believe that as counsel, you had made that statement in open court before. Is there any stipulation that that lab has been confirmed positive?
Judge, I will not stipulate to it as far as an admission by Ms. Red. I will tell the court that that result did come back from the lab and it was confirmed as a positive test. I will make that admission.
All right. Thank you, sir.
For the purposes of this hearing.
Yes, sir. For this hearing. All right, then based on the evidence, the court will find that $100,000 bail in this case is excessive. Court will reduce that bail. Court will find that Ms. Red had violated the conditions of her bail and the conditions of her community supervision for the purposes of this hearing and adjudicating the bail issue by testing positive for the illegal substance of methamphetamine. The court will set bail at $50,000.
Judge, I have a order that I've worked up this morning. I just was waiting for the court's ruling. I'll make the change, put that what the court's ruling is in that, and I'll get it e-filed here the next 5 minutes.
Yes, sir. You can do that, or if you want to, you can just email that directly to my criminal coordinator, Ms. Patty Taberham.
Just email it to her instead of e-filing it? Okay.
It'll save some time, and then I'll get it signed and we'll get it filed for you.
All right. Thank you, Your Honor. That's all the business I have. May I be excused?
Yes, thank you, Mr. Green.
Thank you.
I appreciate the help at the jail this morning in setting up the hearings.
You're welcome, Your Honor. May we be excused?
Yes, sir, you may. Thank you, sir.
Thank you.
Is Mr. White ready on the plea for Mr. Sherwood?
Judge, I have the paperwork completed, I believe that.
Yes, sir.
I see Mr. Sherwood. Okay. Are we sworn on everything, Ms. Houser?
I believe so, Judge. I looked through there, but I hate to tell you wrong. Yeah, I'm missing your signature. Scribbled it out, changed it. And that's just for the court's record, Mr. Officer Sherwood also had a pending DWI that was the basis for the felony MTA, and so we're taking up both of those. We have paperwork for both of those.
All right, court calls CR 18-28 and also 2020-405, State of Texas versus Christian Michael Sherwood. All right, and the only, I don't see a major issue, but on the judgment adjudicating guilt on the felony case, the terms of plea bargain section on the judgment, there's no recommendation that the sentence be suspended and he be placed on 8 years. Later in the judgment, it's going to reflect that the court would suspend the sentence if it follows the plea agreement. Are you comfortable with that, Mr. White?
Let me take a look. I thought I saw something on the front
It's,
page.
it's not in the write-out, Jeff, but it is checked on the face of the
Let
judgment.
me illustrate what I'm looking at here. So if you look at the misdemeanor
Yeah.
here, where it says the recommendation here is for the sentence, and that it be suspended, and that it be placed on community supervision. Here, we don't have that. So at first glance, I thought it was a 10-year revoke, adjudicated revoke, 10-year. See down here where we have this section?
I think that big X probably.
The big X probably has some legal significance.
Yes, I think it does.
So, okay, if you're comfortable with that, then I am as well. I just want to bring it to your attention.
And just for the record, that is the same recommendation, is that it being suspended.
Okay. All right, Mr. Sherwood, I need you to raise your right hand, sir, and place you under oath. Mr. Sherwood, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. You are Christian Michael Sherwood, is that right?
Yes, sir.
This one. And Mr. Sherwood, you are represented by your attorney, Mr. Jeff White, in both of your cause numbers, the one wherein you've been indicted and placed on deferred community supervision for the second-degree felony offensive aggravated assault with a deadly weapon, and 2020-405, wherein you've been charged by information with driving while intoxicated, a class B misdemeanor. He's representing you on both of these cases. Are you pleased with his representation of you? Do you feel like you've had sufficient time to discuss these cases and the legal consequences for you with Mr. White? And Mr. Sherwood, are you a United States citizen?
Yes, sir.
You do read, write, and speak English?
Yes.
And have you ever been diagnosed with any type of mental condition? Mr. White, do you believe Mr. Sherwood to be competent today?
He is competent today, Your Honor, and I believe he's able to make the decisions that he's made today.
And you believe that he understands the nature and consequences of his pleas today?
Yes, I do.
All right, Mr. Sherwood, it appears to me that on your community supervision case, to resolve the state's motion to adjudicate, the agreement you've reached with the state is that you'll be pleading true to the counts alleged in the state's motion to adjudicate in exchange for a recommendation that your guilt be adjudicated. That means that you get convicted of that offense and that your sentence be assessed at 10 years confinement in the Texas Department of Criminal Justice, but that the state is recommending to the court that your sentence be suspended and that you be placed on community supervision for a period of 8 years. At the same time, in your Class B misdemeanor case, it appears your agreement with the state is that you would plead guilty to that offense for the recommendation of 180 days in the county jail, with that sentence being also suspended and you being placed on community supervision for a period of 1 year, along with restitution, fines, court costs in each one of your cases. Is that your understanding of the plea agreement in each case? Yours as well, Mr. White?
That's correct, Your Honor.
Mr. White, does your client waive the formal reading of the state's motion to adjudicate that was filed on October 22nd, 2019, which alleges 2 counts?
I believe the state may be abandoning the first count, but we will waive the reading of the motion to adjudicate.
Is there an abandonment by the state of any count?
Your Honor, the state was not planning on abandoning, since there is also going to be a contemporaneous plea of guilty in the DWI, which is count 1. We were under the impression that we were.
Just
Go ahead,
say-
take one.
Yeah, we have 5. Oh, I'm sorry, I believe that's count 2. Judge, the anger management count, which I believe is count 2, will be abandoned by the state. Mr. Sherwood did comply with that and provided proof to the state of that.
Okay, so state's abandoning count 2.
Yes, sir.
All right, and he waives the formal reading of the motion to adjudicate.
That's correct, Your Honor.
All right, Mr. Sherwood, as to count 1 as contained in the state's motion to adjudicate, how would you plead to that count? Is that count true or not true? And are you pleading true to that because in fact that count is true and for no other reason? Has anyone threatened you, forced you, or pressured you to plead true to count 1 in that motion? Court will accept Mr. Sherwood's plea of true. In this cause, Mr. White, any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A?
No, Your Honor.
All right, court admits State's Exhibit A takes judicial notice of Mr. Sherwood's judicial confession in that cause. Mr. Sherwood, in your misdemeanor cause, the Class B misdemeanor offense of driving while intoxicated carries a range of punishment of confinement in the county jail for a period not to exceed 180 days or a fine not to exceed $2,000. Any plea agreement that you reach or sentence that the court hands down must comply with that range of punishment. You understand that? Court finds that your anticipated plea agreement would fit within that range of punishment. Having been admonished of that, Mr. Sherwood, let me ask you, how do you plead to the Class B misdemeanor offense of driving while intoxicated alleged to have occurred on September 13th, 2019? Guilty or not guilty? And Mr. Sherwood, are you pleading guilty to that charge because in fact you are guilty of committing that charge? Has anyone threatened you, forced you, or otherwise pressured you to plead guilty to this charge? Court will accept Mr. Sherwood's plea of guilt in cause number 2020-405. Mr. White, any objection to the admission of State 1, the stipulation of evidence?
No, Your Honor.
All right, court admits State's Exhibit 1, stipulation of evidence, and takes judicial notice of Mr. Sherwood's plea of guilt in this cause. Anything further from the state?
No, Your Honor, the state would rest and close in both causes.
Anything further from the defense?
No, Your Honor.
All right, based on the evidence before the court and cause number CR 1828, the court is going to find that Mr. Sherwood has violated the terms and conditions of his community supervision. The court will follow the plea agreement in this case. The court adjudicates Mr. Sherwood's guilt for the second-degree felony offense of aggravated assault with a deadly weapon. The court will assess his punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will find it's in the best interest of the community and the defendant for that sentence to be suspended. Mr. Sherwood is placed on community supervision for a period of 8 years. He's ordered to pay the balance of his financial obligations, including a $4,000 fine and $123 court costs. In cause number 2020-405, based on the evidence, court finds that there is sufficient evidence to substantiate the guilt of Mr. Sherwood for the Class B misdemeanor offense of driving while intoxicated. Court hereby convicts Mr. Sherwood, follows the plea agreement, assesses his punishment at 180 days in the county jail. Court suspends that sentence and places Mr. Sherwood on community supervision for a period of 1 year. Court orders him to pay $60 restitution. Court orders fines of $100, reimbursement fees of $1,500, and court costs of $270. The court orders these cases to run concurrently. All right, Mr. Sherwood, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of your sentence. I'm going to have you come up here with my bailiff to be fingerprinted, after which you're to report to the probation officer. Mr. White, anything further?
I believe that's all I have.
Mr. Nolan White.
He's on hallway, Judge.
going to take a 20-minute recess. I'd like to meet with Mr. White, counsel for the state chamber. Trouble, big time.